Judge Mogen thought this would be a simple probation hearing until the defendant's excuses started falling apart one by one. What began as a request for just 51 days in jail suddenly exploded into a brutal courtroom reality check, and by the end, the judge increased the punishment to 120 days while warning that 15 years in prison was still hanging over her head.
Mother, she said, I don't know, she's probably at her apartment. At that time, I was under the understanding that she was no longer living in Cumberland, Wisconsin, and that she was back in Turtle Lake. So I issued a warrant for her arrest, and she was pulled over by Cumberland Police Department.
Yep.
Okay. She was pulled over by Cumberland Police Department. They did give me a call. She had her children in the vehicle with her and requested how they should move forward. I did let them know that she should be taken into custody so we can deal with these violations. Her vehicle was searched, nothing was found. She was placed into custody. I got a statement the same day, or possibly it was the same day. I got a statement from her in regards to the violations of encouraging another client to violate probation. She was very well aware that Joseph Carter was on probation and had a no contact with her. And this had occurred months prior. And
that was a no contact provided by DOC.
Yes, yes.
So she hasn't violated the no contact with Mr. Nelson or Ryan Wren?
No. And then I had just asked her questions about where she was, what her plan was, why she's not in Polk County. Her response has been that she does not want to transfer offices. So this is her reasoning for reporting an incorrect address and giving us her mother's address. And while I empathize with that, it is a requirement that you are supervised in the county, that you do reside.
I don't empathize. I have not been able to speak today with that.
Me either.
Because that's the law.
Exactly.
And that's the rules. And if she likes you as her agent, that's great. Maybe a wonderful agent that's able to move with or hold them accountable and be nice and work well, but that's the rules. The rules are the rules.
Yes.
Okay, so continue. Or is that all?
And then as far as not contacting me, she stated that she does not have funds for a cell phone or for gas, food, etc. So basic needs. And that is why she did not report to my office. And she did state that she didn't have reporting instructions, which, as far as I am aware, a Burnett County siren agent out of the siren office did give her a report date of when she should be seeing me, and she did not show up. Following her being placed into custody, I sent a request to obtain a UA. It appears that on July 2nd, 3rd, and 4th, she failed to provide a UA to jail staff. And then I followed up after the holiday weekend, and they had stated that after multiple attempts, she still did not provide a UA. And after the 4th, it was not requested again. So at this time, I do not know if she was under the influence of any illegal or illicit substance since being released from the Barron County Jail until up to the time that she was placed into custody.
All right, thank you. Ms. Nelson, I'm now going to ask if there's anything that you would like to say to me or you would like to let me know as it relates to this matter. I believe, are you still just asking for, I believe it's 51 days?
Yes, ma'am.
51 days of conditional jail is being requested. You requested to have a hearing and I just need to make you aware that, and I'm sure Ms. Bebo made you aware that on a probation review hearing such as this, in which conditional jail is being requested and the court is being asked to modify the judgment of conviction, the court has no obligation or duty to follow the recommendation of the Department of Corrections, meaning that I do not have to order 51 days conditional jail. I could order 0 if I find that it's appropriate. I could order up to a year if I find that that's more appropriate. You have the ability and right to say what you wish to tell me. This is not like any other criminal court hearing you've had, because I can use your silence against you. So please let me know what you would like me to consider and what you are asking of the court.
Regarding the contact with Joseph, I was informed by his PO that we are able to have contact as long as we're both doing what we're supposed to be doing. And she was fine with us writing for having contact while he was in jail. Along with the Turtle Lake address, I went to my Cumberland apartment to pack it up so I could move out of it. And when I got out of jail, I didn't have the funds and things didn't go as planned, but I did not receive an appointment from Burnett County, the guards here the agent. She did not tell me a report date when I got out, so I didn't miss appointment on purpose. And when I got pulled over, I was gonna drop my kids off and come to probation, actually. That was my plan. But I got pulled over first. Yeah.
All right, so anything else?
No, I don't believe so.
So go ahead.
The rest of all of the stipulations you gave me for completing paper, I've got through all of them and I'm in the process and will have my GED or HSCD within the next 3 weeks here at the jail. They have a program. So I'll have that complete as well. And yeah, I've done all the parenting classes and everything else. I just have to finish my HSCD and pay my $500 and some, I think it is. And
So you had gainful employment?
I did in March, or before I went to jail then. And when I get out, I'm planning on going to the Butterfly House now, which therefore I will have immediate gainful employment. And yeah.
The other condition, another condition was no use or possession of alcohol, illegal drugs, paraphernalia, any controlled substance without a valid prescription. Are you telling the court you didn't violate that?
I didn't. 2.5 years, that was good. I had a miscarriage and it slipped up, but it was a minor slip up and I was already getting sober again when it all came to service, and I regretted it ever since. And
Is that why you avoided your agent in February?
No.
Why did you avoid your agent for those 3 days?
Oh, well, I was in jail. I just had a miscarriage. I was depressed. And
No. Was it February 2nd, 3rd, and 4th?
That was July. So I believe what
Sorry.
she's referring to is the last conditional jail time that was ordered previously.
All right, but with this July 2nd, 3rd, and 4th, when you were being asked to go meet with your agent, why were you avoiding that?
Judge Mogen, I apologize. That was the corrections officers at the Barron County Jail who were requesting or directing her to provide UAs, and she was refusing.
All right,
yes.
Thank you. Okay. And she just said she was unable.
I did not get a response as far as what she had said, was just that she would not provide one after being asked multiple times.
Okay, why didn't you provide a sample for the corrections officer when you were in custody?
The first time was right before I gave my statement, and I still hadn't received a glass for water. I was there for 2 hours and they were busy. And the second time, I don't know.
How about the third time?
I don't even remember being asked a second or third time, honestly.
All right. So if I am to believe the statements that you're telling me here today, are you telling me that Miss Bebo and her connections and the information provided to her are wrong and are lies?
I'm not saying she's lying, but it's not, I don't know. The address thing is not what, I don't know.
You never told her that you didn't update or give your correct address of where you're living, which is a requirement.
Yeah, and she knew
because you didn't want to move or transfer agents?
She knew about the apartment address, and I told her I was moving back in with my mom, which I was moving back in with my mom. I just had to go pack up my apartment. That was,
Ms. Bebo, were you under that impression? Did you know that she was just going to that apartment to pack it up?
No, Judge. I was not aware that she was living in Cumberland until she was arrested and served conditional jail time the first time. And then I was again under the impression that she was being evicted and would be living with her mom upon release.
yeah, that was,
Is that accurate, Ms. Nelson?
yeah, that was my plan, was moving back in with mom.
Now, what I'm asking, if it was your plan, because your plan was wrong and it was violating DOC policy, state law, and the court's conditions of your judgment of conviction. So I have, all I'm hearing from you, all I've heard from you, Ms. Nelson, are excuses, why I didn't do what I was told to do, why I didn't do what I was legally supposed to do, why I didn't do what Department of Corrections requires me to do. Because I've heard excuses and the opposite of what Ms. Bebo has stated here in court. And so you're essentially telling me that Ms. Bebo is lying.
That's not okay.
And it's hard for me to believe that the day that you were pulled over with your kids in your car, you were driving to drop them off so that you can go see probation. It's always that. I'm going to tell you, this isn't the first time I've heard this. People are always on their way to Department of Corrections to turn themselves in. They're always having an interview the next day when they're in custody or the day of they got picked up. They're always starting a new job, and so they need to be released from custody. They're always doing what the court told them to do, but for the fact that they got picked up and they got arrested. All I heard were reasons, again, that were completely opposite than the information and facts that I was provided by Ms. Bebo. I need to state that you were given a very, very sweet plea deal. But for the fact that your attorney argued for your rehabilitation, you faced a very serious prison sentence. It's a Class E felony, That means you could face 15 years of incarceration, 10 years of initial confinement, and then the 5 years of extended supervision.
Mm-hmm.
That's hanging over your head right now.
I understand.
That should be a huge hammer hanging over your head, where you say, Ms. Bebo, I'm going to do everything that I need to do. I need to follow the law. I need to follow the judge's orders. I need to follow what the Department of Corrections is requiring of me.
Mm-hmm.
You were also provided the ability to reunite with your children, because during that time, I can't recall if it was Barron County, removed your children from your care. I understand relapse, and I understand it very completely with doing the treatment court. That happens.
Mm-hmm.
This courtroom hearing quickly turned intense when a woman facing probation violations stood before Judge Mogen, hoping to avoid serious jail time. The defendant had originally received what the judge called a very sweet plea deal in a felony methamphetamine case. Instead of prison, she was given probation and another chance to rebuild her life. But according to probation officials, that opportunity was now slipping away. The Department of Corrections accused her of multiple violations, including refusing drug testing, failing to report to probation, giving an incorrect address, and maintaining contact connected to probation restrictions. Prosecutors requested 51 days of conditional jail time. When the judge gave her a chance to explain herself, she admitted to a relapse after suffering a miscarriage and claimed she had been trying to get her life back on track. She told the court she completed parenting programs, was working toward her GED, and planned to return to employment after release. But Judge Mogen wasn't convinced. As the hearing continued, the judge became increasingly frustrated with what she described as excuse after excuse. The defendant claimed misunderstandings, communication problems, and financial struggles prevented her from following probation rules. But the judge saw it differently. At one point, Judge Mogen delivered a sharp warning that completely changed the tone of the courtroom. She reminded the defendant that she was already avoiding a possible 15-year prison sentence, including 10 years of confinement and 5 years of extended supervision. The judge said that kind of punishment should feel like a huge hammer hanging over your head. Then came the moment that shocked the courtroom. Instead of approving the requested 51 days, Judge Mogen more than doubled the punishment, ordering 120 days of conditional jail time. She accused the defendant of criminal thinking and warned that continued violations could eventually lead to full revocation and a long prison sentence. Even while acknowledging the emotional pain of the miscarriage and relapse, the judge made it clear that accountability still mattered. She ordered additional rehabilitation programs and stressed that probation is not something to be taken lightly. By the end of the hearing, the message from the court was unmistakable. Second chances come with strict conditions, and once trust is broken, the consequences can escalate fast.
5 years of extended supervision hanging over your head. That is nothing that you should take lightly. So 120 days from date of arrest or pickup. And it appears that I'm going to have more probation review hearings with Ms. Nelson because she's not understanding the risk. And if not only does the Department of Corrections, but if she needs the court to babysit her to make sure that she understands that risk, I will. I can do October 6th at 2. Zoom is approved for the agent. If she is out of custody, if you are out of custody, you must be here in person. If you are not out of custody, I think you should be, but you can be by Zoom as well. Anything further, Ms. Vivo?
No, ma'am, thank you.
All right, thank you. We are adjourned.
I don't know what to say anymore, because one minute me and Michelle agree upon a bunch of other stuff and everything's going good, and then all of a sudden her lawyer's got to poke her nose in it and get involved and then cost her more money.
We will go on the record in the matter 24 FA 78 in re. Ms. Gionis, I believe this is your motion.
It is, Your Honor. We were here on May 1st in front of the commissioner, and there is an order on motion to compel and an order on motion for contempt. And on the motion for to compel, the respondent agreed, and it was ordered that he provide answers to our interrogatories and provide documents that we had requested on March 3rd. And that date was set to be May 9th, that he would have that information to us. That did not happen. And that's when we then filed our motion that we are here today on. And then there was also an order, let's see, order on the motion for contempt. In November, Mr. Chanel agreed and was ordered to keep the mortgage payments current, his car, and the Royal Credit Union. The last payment was in January. My client had gotten a letter from the lender saying if it wasn't brought current by June 6th, they would start a foreclosure. And so the court held open a finding of contempt. And that also, the date was set that he would bring that current by May 9th. And I'll have to add that this was by stipulation in the court with the court commissioner. That payment had not been brought current, and thus we filed the motion that we are here on today, requesting that it be found in contempt and that sanctions be entered. In addition, at the first hearing, we asked for $1,000 in attorney's fees. We agreed to hold that in abeyance as a incentive for Mr. Chanel to comply by bringing the payments current and answering the discovery request, which he did not do. So we would ask that the court would enter that request. And then we also requested $1,000 for today for having to bring this motion because discovery had not been provided. And at the time the motion was filed, the payments had not been brought current. Now, about 2 weeks ago, Mr. Chanel did bring the mortgage current. My understanding, it is current as of June 4th, which is when the payment was due. Nevertheless, we had filed our motion and we are here. We emailed him the motion, we mailed him the motion, attempted service. He had already left for his job in Montana, but did know about today's hearing, and that's why he is here. Today in the hallway, he did provide me signed authorizations for his retirement account and a signed financial authorization, which I had requested. He hasn't filled out the financial disclosure statement as is required by statute in order for the final hearing to be complete. And he provided me pay stubs. I believe, I haven't had a chance to look at them because he just gave them to me. But I believe what he said is they go back to the beginning of the year, which will be helpful. Just a little background, these folks have not filed a joint income tax return. Was it starting in 22? You didn't do it in 22? For sure, 2023 and 2024. And I don't have W-2s. Mr. Chanel indicated today that he can get those, and I've asked him to do so. Even though he signed the retirement authorization, he has told me that it's Wilson McShane. He's told me that, but he hasn't, provided any written answers to anything. So that is where we stand on that. We would like him to be found in contempt, keeping in mind that he did bring the mortgage payment current, but we've had to attend 2 in-person hearings on this. And that's, part of the reason the attorney's fees are so high is Ms. Phelps is paying me to drive here and have a court hearing and drive back, in addition to drafting our motions and affidavits and so on. And it's expensive to do this in order to try to get Mr. Chanel's compliance. Also today, I would ask that the court would set this for a trial date because we're getting nowhere. So we should have a trial date.
Ms. Jonas, would you think that it would be a half day or a full day?
I think a half a day should do it. Yeah.
All right, Mr. Chanel, your response?
I don't know what to say anymore, because 1 minute, me and Michelle agree upon a bunch of other stuff and everything's going good, and then all of a sudden, her lawyer's got to poke her nose in it and get involved and then cost her more money. So it's like 1 minute, it's like we were gonna make it work, 1 minute we're not. So why do you think I procrastinated that? That's why.
So, Ms. Jonas,
I
what are you still waiting for the interrogatories and documents?
We have no written answers, none.
didn't say anything about mailing it back in.
And they are abbreviated. I did not send out, like a lot of attorneys will exchange. I think there's 13 questions. And the same on the production of documents. We haven't received any documents except we did get now pay stubs, and he signed the authorizations for financial information and for retirement. But again, I haven't, received any documentation on that, like any reports, values, anything like that. We have no knowledge and no financial disclosure statement.
All right, okay, Mr. Chanel. Do you understand or do you know what questions she's asking?
Yes, I understand, but the reason why she didn't get it is because Shelley, we were gonna work on it. Wasn't supposed to come this far, and this was just recently. And then all of a sudden, boom. So that's why she didn't get them. I mean, they're signed, they've been signed, they just,
Where are they?
she has them. I didn't know I was supposed to mail them to her.
Oh, wait,
I had to give them to you when we came to court again.
he showed me, he signed a blank financial disclosure statement that I sent him. He signed it and dated it. It's not filled out.
It says signed. I didn't know you gotta fill it out, and she already had it all filled out.
And so, Mr. Chanel, that's the law. The
Oh, I
law
know.
is you must do the financial disclosure statement, not just for Ms. Jonas, but for the court, because I need that
And
document.
when I seen it though, when I looked at it, it was already, Shelley had everything filled out on it.
You have a copy of it here?
This is what she had all written down here, party 1, party 2.
We sent him Ms. Phelps' financial disclosure
And it had
statement.
mine on it too.
And Mr. Chanel, in looking over the amounts and the numbers and the things that Ms.
Yes.
Phelps has put on there, are they accurate?
Yes, I mean, I had, like, Shelley always took care of like our financial stuff, so she had access to everything. So, and as far as everything else on here, it is accurate. That I know of.
Well, then for the record, the court will use and accept what Ms. Phelps has put down. So if there's anything that is not accurate, unfortunately, it's not going to come into evidence.
And the only thing that was on here that ain't on there is her current balance on her vehicle, and that should have been both of ours. It's in both our names.
And Ms. Jonas, did you say you filed a financial disclosure? Yes, you did.
Okay.
All right, then in looking at it, Ms. Jonas, do you have any objection to any of the court using the information that's provided by Ms. Phelps?
No,
Except for
with
maybe a
the,
more accurate income because it says approximately.
exactly, the income was an estimate on her part. Now that we have pay stubs, we can define that better. Let's see. The retirements, his retirements are the thing that we have no value. Hopefully we can find that out.
Now that you have the authorization, you should be able to access that. And then you have his income, so you should be able to access that. Is there anything else in the interrogatories that are specifically related to the financials?